Okay, hello everyone and welcome. Good afternoon. My name's Chris Moorcroft. I'm a partner at Harbottle and Lewis in London. I'm a lawyer specialising in wealth structuring, and I'm very pleased to welcome you to the launch event of two new groups. First, TL4 Private Client, which is a new global community bringing together practitioners across the world of private client work. And second, within that, the Next Gen Wealth Initiative, which is the bit of TL4 Private Client that is targeted at the next generation of wealth and the next generation of advisors. I personally have felt for some time that the non-contentious private client world in particular lacks a really thriving community aimed at the next generation of the wealthy and their advisors. And this is very much what I hope this will become. So I would encourage you all to get involved in the community. Thanks for tuning in today. And also to encourage your colleagues to sign up and do the same. I'm going to be joined today by my fellow members of the Next Gen Wealth Founding Committee. We're spread across various jurisdictions, across different types of firm, different specialisms. And we'll each be speaking for no more than 5 to 10 minutes per person. If you want to ask a question, please feel free to use the Q&A function or the raise your hand function if you prefer to come in live on video or audio, whichever you prefer. We'll be taking questions at the end. We've left a decent amount of time for questions, but please do feel free to get involved and make this as interactive as possible. Also, if anything goes wrong on the tech front, then apologies in advance. I have literally no idea what I'm doing here, but we'll try and muddle through. Okay, I'm going to start by setting the scene for some of the topics that we'll be covering today, and also over the coming months in other conferences, webinars, etc., that the group will be putting on. It would be tempting to start with COVID-19, but before we focus too much on the current situation that we're all going through, I want to first go back 12 years to May 2008. And this is pre-Lehman Brothers, pre-Fannie Mae and Freddie Mac. Government deficits were relatively low. There had been no bailouts. George W. Bush was the president. This is even pre-Obama. Things like Trump and Brexit were miles away. And for the wealthy, the world was a very different place. The private client world was a very different place. There was little tax information sharing, no FATCA, no CRS, no UK-Swiss agreement or LDF even. No BEPS, no DAX 6, relatively few offshore data leaks, certainly no Panama Papers. In the UK tax world, we were only just beyond film schemes, which peaked between 2004 and 2007. Things like SDLT avoidance was still common. Tax avoidance schemes were still quite common. So if you think about everything that has happened in the intervening 12 years that affected the private client world, the 99% versus the 1%, the backlash against the wealthy, the backlash against offshore, increasingly aggressive tax authorities, the line between avoidance and evasion blurred. Secrecy pretty much ended, FATCA, CRS, beneficial ownership registers, wealth taxes, the data leaks, blacklists galore, attacks by the EU and OECD on offshore territories, deep public suspicion of trusts. Think about the huge social changes that we saw in the last 12 years. The rise of populism, Trump, Le Pen, Farage, the rise of the left, Corbyn, Sanders, and the emergence of these big generational differences, with millennials and Generation Z prompting us as advisors to look at things anew like ESG and impact investing, a boom in philanthropy, AI, and younger age groups voting in a completely polarized way to their elders. When we talk about the next generation of clients, we're dealing with individuals that often have a completely different set of views and values to their parents. And yet that generation is about to inherit trillions of dollars over the coming years from those same parents, whether it's the million or two of a property wealth somewhere in Middle England through to the billionaires. So the pace of change in our area in the last 12 years has been huge. It's been extraordinary. And that's before we even get to coronavirus, probably the biggest global event since World War II, which will impact how society functions in ways that we can't even yet begin to comprehend. But one thing we do know that will have a huge impact for our clients is the enormous hole that is being created in the public finances and the imperative to raise tax revenues to pay for it. And the public in many places, most places, will expect that burden to fall much more on the already wealthy than those without wealth. And whether that is through taxes on income or capital, wealth or inheritance, whether that is through even more transparency, major changes are coming. A leaked Treasury document in the UK the other day forecast that Britain will have a £337 billion budget deficit this year. The upper limit of the estimate was over £500 billion. These are numbers that will dwarf what happened in 2008, and that is replicated across the globe. And that is with the backdrop of many governments' finances never really having recovered from 2008. And so make no mistake, the world that emerges from this and the world over the next 12 years will be so utterly different from the world that went into this pandemic. And it will be unrecognizable from the world as it was in 2008. And that is the world that we and our clients are stepping into. It's the world that our next generation of clients will inherit. And we know that in addition to all those challenges, those clients will be more socially conscious than ever before, more environmentally conscious than ever before, more connected, more tech savvy, and in many parts of the world, far more socially liberal than their parents and grandparents. That is the generation that many of us are already advising, and we will advise more and more of them in the coming years. And it's the transition of wealth to that generation that represents such an important part of what we do. But we also know that putting all that aside, some of the challenges that wealthy clients face remain constant. Our clients will face many of the same worries that wealthy people have always faced. How do I protect the wealth? How do I pass the wealth on to my kids without spoiling them? How do I avoid future generations falling out over the wealth? How do I keep my family safe? How do I pass on family businesses? And ultimately, how do I ensure that the wealth is a force for good, not a source of tension and conflict? And it's that combination of the old problems and the tried and trusted solutions, together with an understanding of the changes that are coming and the scale of those changes, and also an understanding of the mindset of the next generation. That is what is needed to advise our next gen clients on their wealth and to help with the transition of the wealth to that next generation. But of course, it's not just our clients. This pandemic impacts all of us and the way we work in ways that we could never have foreseen even 3 months ago. And that is why I think a group like this is so important and so needed in this area, in sharing knowledge and best practice of the changes that affect our clients and that affect us. And so, with no further ado, I would like to introduce our next speaker, Rob Dobbin of Walkers in Jersey. And Rob is going to talk to us about something that is extremely topical and affecting us all in our practice, namely the execution of documents in a world of social distancing. So, hi, Rob. First challenge of the tech. Are you there?
I am, and have I managed to unmute myself?
You have. Well done. Very successful. That's right. That next gen tech savviness coming out. Last time, when we did a rehearsal for this last week, Rob, you've grown a pretty luscious beard, but I see you've had a shave. So
well, yes, thank you. I've had a shave. I haven't managed to find a haircut yet, but on the list. Yes, thank you very much. And hello everyone. Good afternoon. I hope you're all well. I hope everyone's enjoying the view of multiple spare bedrooms that you get on these calls. If I've learned anything, it's that Turquoise and O'Donnell are in, and Magnolia is out. But I'm actually in the office today, so you won't get any hints from me. So I'm going to spend just 5 minutes quickly running through some practical points around executing trust documents while most of us are still working from home. So this is going to be quite specific. I'm going to aim just for 5 minutes, maybe a little bit over. And I know many of you are going to have grappled with these issues already, so I hope this is going to be helpful. What I'm aiming to do is just to give you a basic framework that's going to give everyone a guide on the things to think about. And since lists are all the rage on the internet these days, I'm going to start with a top 3 things to think about, and start in general. So the general starting point is whichever jurisdiction you're in, it's always going to be worth considering whether the laws of your jurisdiction impose specific execution requirements on documents. Do you, for example, need to use a deed? What does that mean? And I mean, just speaking from a purely Jersey perspective, that's a nice, easy one, because in fact, there is no general requirement that trust documents be signed in a particular way. In fact, if you look at the trust law, apart from establishing unit trusts, which do need to be in writing, you don't need anything in writing at all. So it's a pretty low bar to start from. It's very flexible and permissive. Of course, I'm not advocating do away with writing completely, but it's nice, as I say, to have that starting point. Point 2, you want to consider, this is Janet and John, Book 1 of Trusts, check your settlement, check your declaration of trust, check your supplemental trust instruments. And the point here is you're trying to identify which powers the trustee intends to exercise, and then check whether their exercise needs to be carried out in a particular way. So if you are using, for example, a power of appointment to make a distribution, it might be that the relevant clause requires the trustee to use a deed for that purpose. Now, one of the quirks of Jersey law is we don't really have deeds. So at least from a Jersey perspective, you will be looking at the definitions section of your settlements, and what does that say? And if that definition of a deed requires you to have an independent witness, for example, then you are going to be stuck with that. But hopefully, actually, we're already at the stage where lockdown is easing a little bit. Finding witnesses is hopefully not impossible. I mean, do bear in mind that, at least as a matter of default, there's no requirement for witnesses to be independent. There are sound policy reasons why witnesses should be independent, because what you're trying to do is mitigate the risk of fraud, forgery, duress, all those sorts of things. But in principle, if you had a requirement to obtain a witness, but it doesn't require it to be independent, then you can satisfy the formalities quite easily with someone in your house. And in many cases, when you look at your trust documents, if there is a reference to needing a deed, it's just defined as an instrument in writing, which to my mind allows electronic signatures, doesn't require any witnesses at all. So just to conclude on point 2, everything needs to be judged on its merits. Each trust needs to be looked at carefully. But so far, we haven't seen too many issues on this front. And that leads me to my last point. And this is where, when clients have been asking me about these issues, what's actually become apparent is that the question is often not really one of trust law at all. important question is whether a corporate trustee can sign documents electronically. And for that, you actually need to have recourse to the articles of the trustee. Now, I'm not a corporate lawyer by any means, but you usually only see problems with older forms of articles, restrictions that might force you to still require wet ink signatures and that sort of thing. But my guess is that this is unlikely to be a problem for most trust companies themselves. It might crop up in SPVs within older trust structures, but hopefully that should be okay. But in practice, what we are seeing a lot of is just a simple step of dispensing with the requirement to attach the company's common seal, as that seems to be logistically the biggest inconvenience. That's presumably stuck in a drawer somewhere while the directors are all working from home. So instead, we're seeing corporates executing using 2 authorised signatories, but not attaching the common seal. And those authorised signatories can sign in wet ink, so they might each have their own counterpart, or they can attach electronic signatures. And again, as long as your articles of association don't impose any restrictions on that, you should be good to go. So on that hopefully optimistic note, I think, Chris, I'm going to hand back to you. Thank you.
Okay, thanks, Rob. Very much appreciated, very interesting. And just to reiterate that, please do send through questions on the Q&A, and then we'll take them at the end when we'll all unmute and come back online. One of the things I'm learning about doing this sort of thing remotely is that unlike when you do this sort of event in person, you get trolled quite extensively during it by people who are watching it. That's happening to me right now, so I'm going to try and ignore that, and instead I'm going to welcome our next 2 panelists. Both English solicitors, but very wisely, neither of them work for law firms. Alice Killingbeck, who is a solicitor at PwC in London, and Joanne Morse, a director of family office services at Summit Trust International in Geneva. Good afternoon, both.
Hi, Chris.
Hello, and are you both coping okay with lockdown? What's the best part about it?
Well, I think the best part and the worst part is definitely child related. It's lovely to spend some time, particularly with my 5-year-old, but the homeschooling is, I think, tricky for both of us. I found out that I'm very, very controlling in respect of creative projects, colouring inside the lines. I have to remind myself that, these are her house points at stake, not mine. So, it's interesting.
I know that feeling. It's painful.
Yeah, I completely agree with what Alice just said. Kids have been a distraction in every sense of the word.
Absolutely. So you guys are going to be speaking about the investment risks for trustees, which obviously is a very topical, again, given what's been going on in the markets over the past couple of months. So please do fire away. Thank
you. So, as we've just heard from Chris about the gloomy economic downturn, we've seen equity and oil markets in free fall, all transactions halted, no country has been untouched by this crisis. This represents a complete nightmare for us as a trustee who are watching the depletion of the value of our trust assets. And they're not necessarily investment portfolios. They can be operating businesses or tangible assets like art or property. And there's very few asset classes actually unaffected by all of this. I did some investment reviews earlier this year with managers, and it's clear that we were totally unprepared, even as the first the data was still coming out. We didn't expect it to go this badly, and lots of managers I spoke with said that they thought this would be a 1-quarter event. But of course, today's headlines talking about the worst recession in 300 years and employment figures matching the Great Depression levels. So, as the trustee, the principles for good trustee investments sound so straightforward and simple when they're written down. But practically, we're finding ourselves having to make quick decisions in a fast-changing environment. I'm going to talk today about some of the issues that we've had to tackle and consider over the last few months. And Alice, it would be great to get some of your guidance and thoughts on that.
Yeah, absolutely. I mean, we know that to avoid breaching fiduciary duties, when exercising investment powers, trustees must act wholly within the confines of the relevant trust deeds and wider law. And I agree, it does sound quite straightforward in theory, but no doubt the current situation is throwing up some really unique challenges for trustees. I think obviously not only in respect of investment powers, but also in caring for beneficiaries more widely. And I think, like all of us, in making sure that your own businesses are operating as smoothly as possible.
Yeah, definitely. So if we can start with the obvious problem of being on the brink of a global recession, we have beneficiaries obviously who are very concerned, who are watching the headlines and calling to say, the markets are up, review calls with managers. But the fact is that we're in unprecedented times and people are second guessing even the experts. I've done review calls where with a beneficiary on the line who's called after a review with a manager to say, okay, well, what do you think? Should we be selling everything? And emotions are high and with pressure to do something. How can we protect ourselves generally from the risks that we face?
Yeah, I mean, these kind of questions from beneficiaries at the moment are, entirely natural and to be expected. But of course, they do flag the need for trustees to manage their own risk. So I think in times like these, the good trustees will be going the extra mile in terms of keeping channels of communication open and managing expectations. And I think reassuring beneficiaries that they're not alone in this, that it's not just them. We know that in certain circumstances, trustees rely on, what we hope are very well drafted indemnities to protect themselves. But, indemnities aren't a panacea. So I think in terms of a sort of practical checklist for now, where investment decisions are delegated to investment managers, it's important to bear in mind that is, a delegation and not a complete abdication of responsibility. And I think in this kind of unprecedented economic climate, trustees should be taking the opportunity to check again, back to basics, check the scope of their duties under the trust deeds, as well as the terms and conditions of any investment management agreements that might have been entered into, some years ago. I think they should be reviewing investment strategy, engaging with investment managers, challenging them and satisfying themselves that those managers are acting sensibly. Where trusts hold corporate structures that may be struggling with the value of any trust-owned businesses in decline, trustees' actions may come under increased scrutiny from beneficiaries sort of in the fullness of time. And the default position under law, as we know, is that trustees have a duty to supervise and to intervene in the management of companies in which they have a controlling interest. So again, it's crucial. Look at the terms of the trust deed to check if that duty has been removed by a so-called anti-Bartlett clause. And if so, to what extent? Case law does show us that these clauses are prone to beneficiary attack. And actually, a recent case, I think last year, Zhang and DBS trustees. In that case, the Hong Kong Court of Final Appeal did provide some comfort to trustees in this area. They applied Jersey law to affect the put into effect an anti-Bartlett clause when considering the investment policy of some Jersey trustees around the 2008 financial crisis. But there is ongoing debate in respect of that case as to whether the same decision would have been made in even very slightly different circumstances. And I think particularly where trusts have what we sort of call a bog standard anti-Bartlett clause. So, get advice, review those clauses and check if there are any residual duties around supervision and intervention, particularly in times of crisis.
Yeah, I think that sounds like really good advice, because the fact is, while we would love to only hold outperforming investments, the reality is we have operating businesses and outsized shareholdings in companies, perhaps due to legacy issues, perhaps due to long-standing family ties, and they might not be the most diversified or risk-appropriate investments. But that doesn't mean that we can rest on our laurels and hope that clauses like that will give us a get out of jail free card. So I think we still take the view that we have to be seen to be regularly monitoring, reviewing those investments and taking part in the board meetings, reviewing the financial data, and perhaps making the unpopular and difficult decisions to make sure that we couldn't be accused of being asleep at the wheel.
Yeah, absolutely. And I think, of course, you know, in preparation for the worst case where beneficiaries do look to trustees to make up for any losses incurred, you know, have a clear understanding of the protection afforded to you under any wider exoneration clauses, obviously.
Okay. But so whilst we've seen that the public markets are suffering, with uncertainty around its recovery, people have been looking to the different areas of investment, and we've seen a lot of private equity investment proposals come our way, which are traditionally more risky anyway, but more of them are sort of becoming more speculative and including things like blockchain technology, cryptocurrency, cannabis related products, and of course with these things, again, they're highly speculative. There's very short sort of turnaround in terms of consideration. Funding's required immediately, so we go from sort of having those exotic assets to having the more traditional income producing investments, like properties where tenants are deferring or defaulting on rent. Holiday rentals are left unused, and as a result you've got income beneficiaries who are receiving next to nothing. So I'm thinking sort of, how do we manage the risks and pressures of that more unusual and speculative investments, and also how can we best manage the interests between our income and capital beneficiaries?
Yeah, I mean, in spite of this stressful and unusual environment, you know, trustees still need to take stock and consider their fiduciary duties and powers when thinking about investments. So, you know, perhaps at this time, rash decisions should be avoided. But obviously, when you talk about cannabis-related products, I mean, I imagine you know, when you're considering those, you have to think about proceeds of crime considerations in certain jurisdictions, and no doubt you have your compliance team working sort of overdrive when they're reviewing those kind of considerations. You know, balance always needs to be struck between wealth generation and wealth preservation, and market conditions influence that from time to time. You know, as we've discussed, good trustees will be communicating clearly and being firm. You know, when it comes to issues of legality, you've got to communicate firmly. But equally, you've got to show, you know, a level of flexibility and commerciality. So I agree, it's not easy. I think, again, practically speaking, you know, when considering any kind of investments, trustees review trust terms and consider, are there actually any restrictions on the scope of powers of investments, a duty to avoid investing in a specific class of assets maybe, or are there clauses making it clear that trustees will be making high risk investments and that diversification is not expected of them? You know, does the settlor or a protector have powers of veto to direct investments? Equally, you know, might a variation of the trustee be appropriate and possible to respond to in the current situation? You know, for example, to lift any restrictions of trustees' powers, or to vary capital and interest entitlements where actually they're just not achievable at the moment. So, you know, overarching point, always ensure that records are maintained and that expectations are managed, and do take legal, specialist legal and investment advice where appropriate.
Thank you. So finally, as we've mentioned, there are trust-owned operating businesses that we're involved with, and succession for head of a family or a key member of a management team, and the next generation taking over from them is never an easy conversation. But I think recent events have really focused the mind on the fact that technology and good health are really critical to enabling businesses and communication to carry on smoothly. And I think it's really reminded us that contingency plans need to be put in place for the operating businesses in particular.
Yeah.
So how can we keep things moving during these unusual times as far as capacity, governance, etc. are concerned?
Yeah, I mean, where vulnerable people at the moment are also settlors, beneficiaries or members of the management team of a trust-owned family business, for example. I think all of our minds turn more than ever to the role of those individuals and questions of capacity and communication. It's something we could talk about all day, I think, but I mean, of course, it may be the time to check powers of attorney are in place, update any letters of wishes with thought obviously given to the to verify the capacity of settlors. But I think, more broadly, when normal life stops like this, it can bring an opportunity actually to make changes and perhaps address issues that have been put to one side in the past. And I think, though, as trustees and advisors, we need to be very sensitive at this time. It may also be the time for us to lead conversations around succession planning and family governance generally, engaging with all the generations to ensure that structures are fit for purpose moving forward. And I think actually that might be one of the legacies for all of us coming out of this crisis.
Yeah, I think it's probably time for us to all have a good review of what we've got.
Absolutely.
Thank you. I'm sure we could talk for hours on these matters, but I think our time's up, so I will pass back to Chris.
Thanks, guys. That was great. Much appreciated. There's some good questions coming in now, including one or two directed at you, but we'll leave them to the end and see how much time we've got to get through them. I think we're going back to Jersey next. I feel a bit like a Eurovision host here. But back to Jersey. Michelle, are you there?
Thank you. Yes, I'm here.
Excellent. Okay, so introducing Michelle Tring, who is a trust director at Acorian in Jersey. And Michelle, you're going to be talking for us about philanthropy and setting up a philanthropic foundation. So please fire away.
Thanks very much, Chris. Hi, everyone. I work with a large team administering structures for high net worth individuals and families. There's been lots of discussion around the impact that COVID has had on our clients and trends that might have emerged. Whilst the nature of communications and transactions have undoubtedly changed, it would be difficult to say that there's been clear trends developing. Our interactions over the course of the last few months have included everything from a need for assistance with cash flow, a view of the markets and monitoring of portfolio performance, right through to urgently updating tax advice based on travel prior to COVID. I thought, therefore, that it might be interesting to talk to a specific matter, which, whilst being discussed prior to COVID, certainly took on a different element subsequent to it. We work with a number of clients who vary enormously, but one particular subject, which seems to be carrying through more often, is that of philanthropy. Prior to COVID, we'd been working for some time with a client who has always made philanthropic gifts from her personal assets. She'd started to talk to us and her wider advisors about ways to ensure that her philanthropic legacy continued after her death. I should note that whilst her children are aware of her wishes, they have no desire to take up her legacy. As I'm sure many of you have experienced, new structures, particularly those being considered by private clients looking to implement a structure to carry out very personal wishes, take time to discuss and implement. Following a great number of discussions and many meetings, we had finally agreed with this client that a Jersey foundation would be the most effective vehicle, offering the flexibility, structure and legal framework to suit her needs and wishes. Most of you, I'm sure, are familiar with Jersey foundations, but for those of you who are not, they're a body corporate, typically viewed as being somewhere between a trust and a company. A foundation has a separate legal personality, a specific purpose, and its powers are exercised by its council, a bit like a board of directors. The council can be made up of any number of individuals, although specific to Jersey law is the requirement for a qualified member, an entity registered under the Financial Services Jersey Law 1998. In this particular instance, the founder had asked that the council be made up of a small number of close friends and associates whom she has entrusted responsibility through their position on the council to fulfil the purpose of the foundation and essentially carry out her philanthropic wishes. In addition, there will be the appointment of an advisory committee whose role it is to identify causes to be recommended to the Foundation's council within the scope of a specific set of terms of reference, which guide the committee as to the causes that should be considered for benefit. The client's wishes being very specific and the drafting of the charter and regulations being particularly bespoke, the establishment of the Foundation had been ongoing for some time. When COVID came along, however, the client in her 80s was understandably concerned at the risk to her own health. The matter of the Foundation and its establishment was therefore accelerated considerably, and whilst we were fortunate enough to be quite far down the line, we had the added complexity of the founder not having the same technology that we might have come to rely on, and having to have the relevant documents signed and exchanged in original. In addition, there were numerous matters which typically we would have discussed with the client and her family in person. Ultimately, however, we were able to find solutions, and the establishment of this particular foundation is in the process now of being completed. Another recent example of philanthropy is that of a client in his 30s, perhaps at the other end of the spectrum to my former example. Having inherited a significant amount of wealth from a family to whom philanthropy is incredibly important, he has been working with our family office team recently to put in place his own legacy, perhaps going against an assumption that the next gen might be inclined to use their own wealth for less noble pursuits. He's been working to determine how much of the wealth his own family will need for their future and carving out a proportion of the excess to pursue his own philanthropic beliefs, different to that of his father and in his own way. COVID to this client has been an opportunity to go the other way to my previous client, and he has set aside his considerations in the short term whilst he waits to see how things evolve. I suppose ultimately the only consistent theme that we see in the world of private clients is that of the need to be flexible and adaptable as service providers and trusted advisors to matters which may come along, whether that be a divorce or a pandemic, and which will naturally require further discussion and consideration. We have to stay on our toes and consistently think outside the box, whether that be in terms of problem solving for a particular problem, or simply to discuss matters and challenge ways of thinking to make sure that ultimately the structure or vehicle being used is going to be fit for purpose over an extended period of time, while still meeting the ultimate objectives that it was put in place to meet. Philanthropy in particular can often be far more complex. From recent conversations, as clients currently have time to consider their philanthropic legacy, I do believe that charitable giving may well spike as a result of COVID. Working with families and individuals with regards to their wealth is a hugely personal thing and understandably takes time. Whilst the new world order may throw up some challenges to the offshore world or even to our ways of working, I have no doubt that what will remain constant is the need to continue to service the clients with an open mind, to find bespoke ways of working to meet their individual needs, and to always be prepared for those matters which you cannot really prepare for. I think that pretty much sums up the last couple of weeks for us.
Yeah, agreed, Michelle. Thanks very much. Very interesting, thank you. And moving on now, the final speaker today before the Q&A is Phyllis Townsend, a senior associate in the wealth management team at Baker McKenzie. And Phyllis, I think you guys at Baker were working from home a few days before everyone else, weren't you? But how have you found the whole lockdown thing?
Fine, actually. I think that we have to be available for clients 24/7, and it's quite nice to be able to do that from where you want.
True.
And from so.
Well, I think where I want would have been a beach in Thailand somewhere, but yeah, I agree. It is helpful. So you're going to talk to us about COVID-19 tax residence issues with a focus on the UK and the US. So please fire away.
Yes. So thank you for that introduction. My internet isn't very strong, so please bear with me if I come and go. I'm going to talk about stranded tax. This is the main issue I've seen. In particular, I was setting up two trusts for two siblings. The non-UK resident is now stuck in the UK and hopefully will be able to leave again because he was trying to break his deemed domicile. And he was already in a position to set up the trust, but he needed to stay out for 6 complete tax years. And then the other sibling, whilst LA might be quite a nice place to be in lockdown, he obviously wants to avoid US tax residence and certainly a US domicile so that he can set up a trust with the assets owned by him. I'm going to say a little bit about the statutory residence test and particularly exceptional circumstances. As you probably know, up to 60 days in the UK can be discounted per year due to exceptional circumstances, and those apply provided that you're present only due to the exceptional circumstances and you intend to leave as soon as the circumstances permit. What this means is that exceptional circumstances don't help if you come to the UK knowing that you won't be able to leave. So, for example, if you come to the UK for treatment or an operation, even though that might seem quite unfair, instead it can cover quite serious events like an accident that occurs whilst you're in the UK, or in this case, COVID-19. So HMRC was quick to issue guidance. I'd say we had guidance in March. And it seemed that if you were already in the UK and the borders to your home country closed, the fact that you failed to leave even for somewhere like Sweden that might have remained open meant that the days in the UK should count as exceptional circumstances. I think the problems with this are twofold. So it's not quite clear from what date you can count yourself as not being able to leave. Is it the 23rd of March when the UK went into lockdown? Or is it an earlier date when it was difficult to get a flight out of the UK? And secondly, the exceptional circumstances only apply to some parts of the statutory residence test. So, for example, the automatic test of being in the UK for 183 days. Similarly, the automatic non-resident test, where you don't want to exceed 16 days if you're a leaver, and 46 days for arrivers. So leavers, obviously those who've been tax resident in one of the 3 prior tax years, and arrivers, those who are newly arriving in the UK. Perhaps most importantly, 90-day tie, which is about not spending more than 91 days in one of the 2 prior tax years. There you can again discount up to 60 days and the sufficient ties table. So that's really helpful. But the problem is that it doesn't apply to some other parts of the statutory residence test. So, for example, the family tie, and there your minor children are relevant. And so usually they might be in boarding school, but now they might be in lockdown with you. So you might have a family tie where you're not expecting one. Similarly, the work tie, and also the limit on work done in the UK if you're trying to meet the full-time work overseas test. So limit your work to less than 3 hours on any day. Once you exceed those limits is probably the practical advice, although it's quite hard to evidence what exactly you're doing if that were ever challenged. And then also the country tie, which is only relevant for leavers, but you can't spend more days in the UK than anywhere else, even if you're in lockdown. Bear in mind, you only get 60 days. I think if it's to be extended beyond that, the government would have to legislate for that, and also to apply the 60 days to other parts of the statutory residence test. 60 days is probably fine for last year, but more problematic this year if we don't start opening up in June. And also you've got some clients saying that they don't feel safe travelling. So that's the other issue. I mentioned that I'm also going to talk briefly about the US, because I've been looking at the US too, and we do quite a lot with US connected clients. The US was a lot slower off the mark to issue its guidance, but then its guidance probably gives a bit more certainty. So if you're stuck in the US, you've also got 60 days that you can discount for the substantial presence test. You can pick a day between the 1st of February and the 1st of April for those 60 days to start. And you've got some possible get outs if you're still going over the days under closer connections or treaty non-residents. So in some ways, the US there's a bit more certainty at the moment, but in both jurisdictions, you've got 60 days, and obviously they don't have the benefit of a tax year end ending on the 5th of April. So the impact isn't currently split across 2 years. Clearly all this is quite impactful for settlors, beneficiaries, trustees, also shareholders and directors. So hopefully helpful summary of what we've seen on UK residents and US residents.
Great, thank you for that, Phyllis. I'm now going to ask everyone to unmute, and we're going to spend the next 15 minutes taking questions, and then we'll try and finish at 1 so that you and we all can have some lunch. There's quite a few questions come in. We might not be able to get through them all, but as we have one raise your hand from Victoria Bruard, I think Victoria deserves the first question. So let's see if we can get this thing to work. Okay, unmute. Victoria, hello. Let's try again. Hello, Victoria. All right, we'll try and get that working in a second. In the meantime, I'll take another question, or actually, because we've got quite a few questions to go through, I'm going to start by sort of combining two, and I'm going to throw it out to the panel. So anyone who wants to jump in, please do. Harriet Quarteng asks about our experiences with different intergenerational views arising in the same family and how it's been dealt with. And the first question from Vanessa Eve is about whether we see the use of family charters becoming more prominent. And so to sort of combine the two, firstly, what do we all think about family charters? Are they really a very useful tool, or just a way of lawyers spending lots of time drafting documents? And then secondly, what other ways have we seen that might help with the different intergenerational views? Does anyone want to volunteer to answer that?
Well, I think, Chris, that actually family charters are, in my experience, quite helpful, if only just to sort of tease out issues initially when talking to clients, and working out where perhaps the tensions actually are within, between generations. I think as long as they don't just get put in a drawer and forgotten about, they can be really useful tools for the next generation to kind of hang their hat on and rely on when bringing up conversations with patriarchs and first generations, to kind of to challenge them and perhaps sort of hold them to account in some way. It's a sort of in my experience a useful tool for clients.
Yeah, I mean, I always, and this is maybe more of an answer to the second bit, but I always stress the importance of communication in trying to solve the sort of intergenerational differences, and for the different generations trying to come around the table and find kind of a common view and a common vision. And I guess that's kind of what you're saying, i.e. that the family charter is kind of a tool for doing that kind of gets people round the table and starts to sort of unlock some of those issues.
Yeah.
Does anyone else have any other views on family charters, or anything else on that?
I wouldn't say that we've seen the use of too many family charters, but we have seen quite a few instances actually where families have used foundations. They seem to be quite a useful tool for that sort of intergenerational planning, and we've seen the appointment of some of the sort of younger generation onto the council, so that the foundation is used as a way to kind of educate them in terms of the family business and so that you get the two generations working together. And we've seen that as quite an effective tool in a couple of instances.
Cool. Okay, moving on. Victoria didn't manage to get the raising hand thing working properly, but at least she volunteered for it. So we're going to read out her question second instead. What is a pragmatic recommended way of dealing with beneficiaries, family members' differing approaches to investment and philanthropy? Well,
again, I mean, I'm happy for other views. I can only talk to my experience. Like I say, foundations have been quite effective, but other families that we've kind of worked with have worked to sort of carve out different proportions of the wealth to give the next generation an opportunity to sort of go off and stand on their own 2 feet and demonstrate, you know, their own views in whether that be philanthropic or in terms of sort of managing investments. So I don't think there's any one recommended way. I think, as I sort of alluded to when I was talking, every single situation is so very different and bespoke that, as you said, Chris, it comes down to communicating, and then it can be an extraordinarily long process. But what is available out there at the moment is a number of things that you can use, such as the foundations and carving out money and family charters, and there's lots of different things that are available to families, and it really just tends to involve communication and working out the best solution, really. And that's why it takes so much time, but inevitably that is where you need to be.
I think it's also maybe worth mentioning things like impact investing as well in this, because if we're assuming that what I think the question is getting at, if we sort of start with an assumption that maybe the younger generation, you know, look at the wealth and think more in philanthropic type terms about it, and the older generation who maybe created the wealth are still much more focused on preserving the wealth and enhancing the wealth, then certainly what the impact investment managers tell me, and what you hear a lot, is that impact investment for kind of resolving that problem is maybe a way of having your cake and eating it, because supposedly the returns from impact investments and kind of ESG and things of that ilk are just as good as conventional investing, and yet, of course, done right, it has much more of a philanthropic feel, because it can be aimed at specific things that family members are interested in and kind of doing good with the world and all this kind of thing. So I've certainly found that impact investing is quite an interesting thing to put to clients as a way of resolving those sort of intergenerational tensions and ultimately getting people around the table. There's a particular question for Joe and Alice here from Tara Hotwood. Would you go to court to ask for blessing on investment decisions?
Well, if I say sort of, Joe, the legal position, obviously, you know, trustees can seek the approval of particular decisions from the court. But I think such decisions, my understanding is that they need to be momentous. You know, trustees are required to sort of carry out their duties in the good times and the bad. So, you know, my view is that they shouldn't sort of just head off to court when things get difficult. And I think probably, you know, in my experience, I think courts are likely to be a bit critical if they feel that trustees are just going to them for their sort of blessing about sort of routine decisions. And also, obviously, there's the practical points at the moment, which would be quite tricky. But I don't know what your views are, Joe.
Yeah, I think practically, totally agree with what you've just said. Particularly in the investment world, we don't have the luxury of time of sitting and waiting for a rubber stamped decision from a court. And I think, you know, that's what we've been appointed for, is to make the decisions, and they're not the easy decisions all the time. And I think therefore it's really important that we can show we're making fully informed decisions and recording them, which is why the monitoring and the reviewing and the communication is even more important.
Yeah, I agree.
Rob, there's a question just on a Jersey question on company execution of deeds. Do memorandum and articles need to permit or not exclude certain methods? Can you?
Oh yes, sorry if I wasn't clear about that. So in the mem and arts, you would be looking for something that's going to trip you up. You don't need something to expressly permit the use of electronic signatures. What you're looking for is something that either specifically or inadvertently is going to require wet ink signatures or otherwise restricts the use of e-cigs. I mean, do bear in mind that purely from the point of view of a corporate, you're still going to have to think about things like the terms of the trust, if the corporate is the trustee of a trust, if the corporate is signing contractual documents governed by the law of another jurisdiction, you have to think about whether that other jurisdiction permits electronic signatures. So there's still other factors to consider, but yes, you are looking for restrictions. You don't need something to permit it.
Mm-hmm.
Thank you. Excellent. And Patricia Boone has a question for Phyllis. In your opinion, how lenient do you think HMRC might be towards those who exceed their exceptional circumstances allowance, or will they be lenient at all?
Thanks for that question. I think the HMRC is unlikely to pursue people in respect of the 60 days, but if you go beyond that and you become resident, you got to file a resident unless they introduce an exemption, a further exemption of 60 days. So I think that at the moment, otherwise you got to be within the tests, and they could pursue you if you don't account for UK residents, or you should be accounting for UK residents. And I also think there's some consistency between jurisdictions. So perhaps if other jurisdictions are more lenient, maybe HMRC will follow. But at the moment, I think you've got your 60 days, and then you've got to see where you end up if you exceed those. The other thing I would say is that they put inquiries on hold at the moment. They're prioritising, and we've had letters saying that your inquiry is on hold. In some cases, they're asking whether you want to pursue it or to hold for another 6 months. And in the particular case I was working on, we decided to continue because we've got a good relationship with the case officer. But I think inquiries are on hold at the moment. Potentially, they're being more lenient with the inquiries. Something strange they've said is that they will destroy documents, and you might have to resubmit all your documents again in relation to inquiries. So that's where we are on those. I think on residents, you've got to try and get out in June if that's possible.
Okay. I'm going to do one more question and make it our last question, and I'm just going to ask each of you to just maybe give me one brief answer, which is the question from Alfred Liu about what tips do each of you have for next generation private client advisors in this post-COVID-19 age. I'll start to give you a bit of thinking time because I lined up, I was going to ask this a few minutes ago. I would say, firstly, the world, this whole private client world is so kind of broad and changing so quickly that it's absolutely critical to kind of try and take in as much information like a sponge. And so read widely, and it's not supposed to be a plug for this group and webinars like this, but obviously, you know, the more things that we can all get by way of information and then share, the better. And also I think for kind of younger practitioners, you know, it's kind of don't be afraid to give your view, particularly on all this stuff, because you know, you, by virtue of being from a different generation and from perhaps the generation of the family members that are receiving the wealth, you may have a better insight than some of the more senior practitioners on particular things. So moving on, I'll, for no particular reason, I'll just start with Michelle, because you're at the top of my screen. Michelle, do you have a tip?
I think I would say to use your experience. You know, we're going through unprecedented times, both personally and in the workplace. We're working with clients on a number of different things, being thrown a number of different curveballs. So use that experience in a practical way, and really know your client. You know, when you're coming out of this, really take the time to know and understand your client, their family situations, their views. I'm sure most of us did that already, but I think what COVID has shown us is that you can never know them sort of too well, and from a practical perspective, we've got more sort of tools available to us to get to know them now. I'm sure Zoom is going to be a hugely popular tool to sort of carry on, so I think if I can take two, they would be those two: know your client and really use your experience going forward from this.
Okay, Phyllis?
I agree with that. I think use the technology. It's amazing how many people would have travelled around the world to have meetings that now happen on a Zoom call. Yeah.
Which is a great thing for the environment, obviously, as well. Alice?
Yeah.
Yeah, I mean, I completely agree with everybody. I think, this sort of environment is quite, it's a leveler, isn't it? We're all experiencing similar things. It's kind of given a bit of a chance to take a step back and have some space, and I think it means that you can really stay close to your clients, listen, and just use the opportunity to build those relationships with the next generation. I completely agree with you, Chris. Don't be afraid to give your own view and your own perspective.
Okay, thank you. Jo?
I was thinking that, with things being a little bit strange, maybe now is the time to be reviewing the structures or the advice that you've received in this brave new world, just to make sure that, we haven't looked at the way that the world is with a fresh pair of eyes, and whether everything is still fit for purpose. And whether there are any of those succession issues that you should probably be tackling sooner rather than later.
Yeah. And finally, Rob.
Oh, thank you. Well, I was going to take a slightly different angle on the technology point. I think the number of platforms that we all now have, the number of different apps and ways of getting in touch with clients, is fantastic in that it promotes immediacy of communication and that sort of thing. And when I think back to 15 years ago when letters used to turn up in the post and that was the start of your day, obviously there were emails, but that was sort of it, really. But I think it's a challenge because certainly for us as lawyers, our job is to understand that sometimes they, particularly for me when I'm out in the Middle East, sometimes they just want a bit of a chat, sometimes they're actually asking for legal advice, and trying to maintain the quality of the advice you give through these slightly restricted means is actually a bit of a challenge for us. So I think that's something we need to be alive to as a profession.
Yeah, that's a good point. I certainly have that problem with various clients who want to contact me on WhatsApp, which is not exactly the best medium for well thought through legal advice. Okay, well, firstly, thanks to all the panelists. Thanks to everyone for tuning in. Sorry we didn't get to all the questions, but thanks for putting plenty in and making this interactive. Do please continue to engage with the group. I hope this was useful. And we will call it a day. Enjoy your lunch. Thanks very much.
Thank you.
Thank you.
Thank you.